Today I'm going to basically update the playbook, the hospital's playbook on dirty tricks that it uses in sham peer review. And so that's what we're going to do today. We'll start kind of with a definition of what is sham peer review. I realize that most of you in this audience know what sham peer review is. It's basically abuse of the peer review process to get a physician. This is sort of the legalistic definition. Sham peer review is an adverse action taken in bad faith by a professional review body for some purpose other than the furtherance of quality health care, and that is disguised to look like legitimate peer review. So basically it's an elaborately scripted event intended to appear fair while having the outcome predetermined from the very beginning. Or as stated by Andy Schlafly, sham peer review is not peer review at all, but tortious conduct labeled peer review by hospitals in order to exploit a judicially created immunity. So before I show you this next slide, I should tell you that the attorneys who represent hospitals hate this next slide. They are offended by it. They are indignant that I should show this slide. And I fully admit that it has great entertainment value, but it also speaks to the strong immunity that is provided to hospitals and peer review under the HCQA law. So the caption reads, "I know it looks like a bullet hole in his forehead, but if we call it peer review, they can't touch us." So this is where we stand. When you provide nearly absolute immunity or absolute immunity, what that invites is corruption and abuse, and that's what we have. So with this slide in mind, let us consider, should the attorneys be offended that this is so outrageous and preposterous? Consider the case of Dr. Michael Fitzgibbons. He had black gloves and a gun planted in his car, and an anonymous caller called 911 and accused him of a road rage incident, waving a gun in traffic, an incident which never occurred. We have the actual 911 call on our AAPS website if you would like to listen to it. He also had drugs planted in his car while it was in the police impound lot after police had already searched his vehicle. And he had the tires of his car slashed, which resulted in catastrophic tire failure while his 23-year-old daughter was driving it on the freeway. The car flipped over, but fortunately, neither the daughter nor the Japanese exchange student riding with her were injured. So who did it? Well, here's sworn deposition testimony from the IHHI president, Larry Anderson, and I quote, "He," referring to IHHI CEO Bruce Mogul, "said Mikey," referring to Mikey Delgado, he told me at one point that Mikey was either mafia or mafia connected. He also told me that Mikey has very skilled resources at planting things. So I was led to believe by Bruce that Mikey had some significant technical capabilities, and I didn't want to be a party to any of that. I didn't want to be involved in any of that. I didn't want to be a victim or a subject of any of that. The former president also testified he was afraid. He was afraid what would happen to him if this all got back to Mikey Delgado. When asked under oath if he, meaning the former IHHI president Larry Anderson, was ever present when anyone suggested that Mr. Mogul was in any way affiliated with organized crime, Anderson testified, and I quote, "I just said Bruce told me he was affiliated. Bruce was clearly affiliated with Mikey. We had numerous conversations about that, and he told me Mikey was mafia or mafia connected," unquote. So, should attorneys who represent hospitals propose that that's a preposterous slide to show. The trial court found for Dr. Fitzgibbons and awarded $5.7 million. But hospitals always appeal, appeal, and appeal. They try to spin the doctor down until he can no longer fight. On appeal, the verdict was overturned by a judge who presumably had at least the appearance of conflict of interest, as one of his retired judge buddies was sitting on the hospital board at the time that he made this ruling. In April of 2015, the California 4th Appellate District, Division 3, reinstated the award. The hospital system appealed to the California Supreme Court, and on August 12th of this year, the California Supreme Court rejected their appeal, upholding the $5.7 million award. So today what I'd like to do is I'd sort of like to update the hospital playbook on dirty tricks, tactics characteristic of sham peer review, which was published in our journal in 2009. You can pull it up and read it if you like. I also made a presentation on it about 5 years ago. Again, that's also posted on the AAPS website. But today I'm going to update those tactics, and I'm going to spend a little time talking about the pitfalls for employed physicians or exclusively contracted physicians. So the following is not an all-inclusive list of tactics which are characteristic of sham peer review, and the ones in white-colored font are the ones that I've covered before. I'll go through them briefly. The ones in yellow are updated. So number one, the ambush tactic is pretty much self-explanatory. This is where the physician is called to an informal friendly meeting in the CEO's office. He's not told what it's about, and when he gets there, he finds himself sitting across the table from the hospital CEO, the chief of staff, the vice president of medical affairs, and the hospital's attorney, and they all know what it's about. They're all ready to proceed with charges against him and bringing out charts of patients for which he has had no time to prepare. There's also secret investigations which hospitals conduct. These can go on for weeks, months, or even years in some cases, where they're sending the doctor's cases out for external peer review, and they don't tell the doctor anything about it so that he could respond and tell his side of the story. Depriving the accused physician of charts, complaints, instant reports needed to defend himself. This is a tactic characteristic of sham peer review. A physician is presumed guilty prior to peer review hearing, and the burden is placed on the physician to prove his innocence. Sometimes that's codified in the bylaws. Numerator without denominator tactic. This is frequently a tactic used against surgeons. And this is where they will come up with some number and say, gee, this doctor has had 3 complications recently. We have to do something to stop him. They don't provide a denominator. That might be 3 cases out of 3,000 surgeries of that type, 10,000 surgeries of that type. But when you don't provide a denominator, you can't compare the doctor's experience with that of other surgeons in the hospital. So hospitals have sort of gotten onto this, and they said, okay, yeah, you caught us using the numerator without denominator tactics, so we'll now provide a denominator. So now what they're doing is they're manipulating the denominator to make it a small number. And there's various ways to do that we've caught them doing that. One way is they can select cases for review. So for example, they might select 4 cases for review and find 2 complications. And then they can claim, wow, this doctor out of the cases we reviewed has a 50% complication rate. Sounds pretty bad, doesn't it? But again, you don't know if those are 2 cases out of 40, 4,000, or 10,000 surgeries done. Misrepresenting the standard of care. This is where hospitals may hire an external expert, pay him $30,000 to $40,000 to review 6 or 7 charts, and the expert comes back and testifies that, well, this doctor didn't do it the way that I would do it, and therefore he's practicing beneath the standard of care. But good qualified physicians often have legitimate, valid differences of professional opinion. There's more than one way to do things. There's more than one procedure to be used in a surgery. And so to misrepresent those valid differences of opinion as a standard of care is wrong. False and/or trumped-up charges, that's self-explanatory. Abuse of the disruptive physician label, of course, we've heard about that many times. Dredging up old cases to justify a summary suspension. Hospitals try this all the time. It suffers from the logical flaw, though. It is, if the hospital knew about this 2-3 years ago, why did they wait for 2 to 3 years if it's putting patients in imminent danger to all of a sudden summarily suspend the doctor? That's the logical flaw. Ex parte communications in peer review, a hospital attorney or a conflicted attorney used to influence peer review process, bias, refusal to allow an independent record of the peer review hearing. In a number of hospitals, the hospital will write into its bylaws that it will keep the record of the peer review hearing. How many places in a court of law do you know where the prosecutor gets to keep the record of the hearing? Never. And again, if the hospital keeps the record, it's subject to sanitizing, editing, and manipulation. And in some cases, doctors have said, look, I'll bring in my own court reporter. I'll pay for it. And the hospital has said no. Improper and/or false report to the National Practitioner Data Bank. Then there's other cases that simply involve a tremendous flaw in logic. In one case, a GI physician was told he was not competent to do endoscopies on weekends, but he could continue to do endoscopies on weekdays. A family practice physician was told he cannot admit patients of other physicians for whom he is cross-covering, but he can continue to admit his own patients for the same type of medical conditions. And he's told specifically he must send patients of other physicians for whom he is covering to the hospital-employed hospitalist for admission. Failure to follow medical staff bylaws or changing the bylaws in the course of the peer review to favor the hospital and to put targeted physician at disadvantage. Then there's pulse surveys that are conducted on a single physician at a facility. And now we get to some of the updated tactics. Attributing deficiencies of the hospital or others to the targeted physician. So this would be like citing deficiencies of an entire program in the hospital that's been reviewed and making that deficiency basically the targeted physician's fault, or perhaps the hospital has provided the surgeon with defective equipment. The equipment maybe breaks or malfunction. Again, that is sometimes attributed to the targeted physician as his fault. Breach of confidentiality. There are times when the hospital will leak the fact that the doctor is under peer review, and they leak this out to the community, basically, through hospital employees that inform patients that, well, this doctor is having some quality issues and he's not practicing here right now. And again, peer review is to be kept strictly confidential. This is typically in the bylaws and is also usually a state law as well. Ignoring the favorable findings of the hospital's own external reviewer. And again, this is just unbelievable. The hospital will send these records out to their hired reviewer, pay them $30,000, $40,000, and the review comes back and it says, well, the doctor was practicing within the standard of care and he actually did a pretty good job. You'd think that might be the end of it, but in some hospitals that's not the end of it. In the case of sham peer review, that's not the end of it. They will ignore the reviewer's own findings and still revoke the doctor's privileges or take some other action against the doctor. Then there's the attempt to pass off a non-peer review report as if it were a valid peer review. And the case that comes to mind, one of the first cases encountered, was Dr. Jesse Cole versus St. James Healthcare in Silver Bow County, Montana. And believe it or not, the hospital actually hired an attorney to do the peer review. There were no peers at all. There were no physicians at all. It was a hired attorney who did the so-called peer review and wrote the peer review report, which of course slammed the doctor. And if you ever get a chance to read it, you should read it. It's the Newman Order, that is the order of the Honorable Brad Newman, who gave the hospital a severe tongue lashing for trying to pass off an attorney review, an attorney report, as a peer review. It's delightful reading. I mean, I can imagine the expressions on the hospital attorney's face as he sat and wrote that. So attorneys are writing that. We found another case where actually it was an attorney of an insurance company that wrote an external peer review for a physician practicing in a hospital. Again, it's an attorney writing it. It's incredible. Another case, a CEO of one of these external review companies wrote the report. Well, that CEO was not the one who did the actual review. It is proper, and external reviews and peer reviews should only be written by the actual physician or physicians who performed the review. Common sense. Misleading the targeted physician about databank reportability. This has started happening quite a bit as well. This is where the so-called leadership in the hospital, who's in on the sham peer review, will tell the doctor and reassure the doctor that, you know, it will go better for you if you just go along and resign, and that way you won't have to go through this horrible peer review, which is coming. And don't worry, you can just continue doing whatever you are doing now, practicing and whatnot. It won't be a problem. And of course, once the doctor resigns, it gets reported to the databank. Once you have an entry, an adverse action report in the National Practitioner Databank, your career is either totally ruined or often over. And so they mislead the doctor. And of course, it represents the best case scenario for the hospital because the doctor voluntarily resigned. And once the doctor has resigned, the doctor is no longer entitled to any due process under the medical staff bylaws because the doctor is no longer a member of the medical staff. There have also been cases of trying to retroactively apply new medical staff bylaws or policies. Well, again, we have something about this in the Constitution, right? I mean, we don't retroactively apply laws, and there is no reason to suggest that it's valid to retroactively apply medical staff bylaws or policies, yet some have tried to do it. Most recently, a former member of the National Practitioner Databank Executive Board wrote a review for a hospital suggesting that newly proposed National Practitioner Databank guidelines, which have not even been implemented at that point, should be applied to the physician under review. And he was an attorney. So it's incredible some of the things that they think they can get away with. So we're going to do a quick peer review on the updated tactics characteristic of sham peer review. Are any of the tactics I reviewed in this presentation fundamentally fair to physicians subject to peer review, and do any of these tactics comply with due process for the accused physician? Raise your hand if you think so. Let the record reflect that no one in the audience raised their hands. So these are actions that are frequently seen in association with sham peer review. Switching prosecutorial theories during peer review from quality care concerns to professional conduct issues. And hospitals typically do this when their case starts to fall apart. They have a weak case, they just can't find a way to support it factually, so they say, okay, it's not really about quality so much as professional conduct. We don't like the way he looks at people. His body language is kind of intimidating. His facial expression is demeaning. I think this is about professional conduct more than quality of care issues. So they'll switch theories midstream when they see their case falling apart. Then there's the pot calling the kettle black. Sometimes you'll find physicians who are out front leading the charge, accusing the doctor of high infection rates or high complication rates that when you look, they have even higher infection rates or complication rates than the physician they are accusing. Then there's the hospital board or MEC overruling recommendations of peer review committees. But peer review committees, when they find that the doctor did nothing wrong, they're the ones that sat there and they listened to all of the evidence. They considered it, analyzed it, and made a judgment, and based their recommendations on all of that time they spent reviewing the records. The MEC typically does not review all of the records and have the first-hand experience and hear the testimony of the witnesses. And MEC oftentimes, if it's a favorable recommendation for the physician, they want to get rid of the physician, they'll say, no, we reject their recommendations and we're going to revoke his privileges anyway. Steering patients away from the targeted physician. This, again, is done typically in emergency rooms where a patient comes in and they'll tell the patient, well, it would probably be better if you would choose this other physician because, well, this targeted physician here is having some quality problems right now. And again, it's a breach of confidentiality. Then there's assassination of professional reputation by PowerPoint. This is typically done by attorneys who represent hospitals, and some are highly skilled at doing it. And when they make these presentations to the board of the hospital, for instance, which typically has a lot of lay members sitting on the board, it's very persuasive. They highlight these things in bold font and have these special effects on the PowerPoint presentations, and it's very, very persuasive to these board members sitting there who are told by the hospital's attorney they need to do something to stop this dangerous physician. So I'm going to talk a little bit now about pitfalls for employed or exclusively contracted physicians, because more physicians, unfortunately, are being driven into either hospital employment or exclusively contracted situations with hospitals. Hospitals have manipulated medical staff bylaws to insert clauses that specifically state the employed physician or exclusively contracted physician will not be entitled to any fair hearing or appeal rights on termination of the contract with the hospital. If you have a contract with the hospital, read your contract and read the bylaws. You may find this clause there. Termination of a contract is generally not reportable to the data bank, but if termination of the contract was related to professional competence or conduct, then it could be reported to the data bank. The physician in that instance would have no due process right to contest the action because of these clauses that they have inserted in the bylaws and clauses they have inserted in the contracts. Hospitals have also inserted a loser pays provision in medical staff bylaws, and you should know that the Healthcare Quality Improvement Act, HCQA, has a loser pays provision under section 11.113, such that physicians who sue hospitals for bad faith peer review, and there is no cause of action for sham peer review, so it's an action related to other torts, and the defendant meets the reasonableness standards of HCQA, and defendant substantially prevails, and the lawsuit is determined to be frivolous, unreasonable, without foundation, or in bad faith, the physician will be liable for hospital attorney fees and costs. And hospitals have started going after some physicians for these costs, and they're huge. If, however, the physician obtains a permanent injunction, such as Andy was talking about earlier, then the defendant will be deemed to not to have substantially prevailed, and the physician will not be liable for hospital attorney fees. So again, another reason to pursue injunctive relief in these cases to prevent, for example, reporting to the data bank. Hospitals have gone one step further than HCQA, and they've inserted loser pays provisions in their own medical staff bylaws, such as if the physician simply loses his case, then the physician is liable for all of the hospital attorney fees. The physician's case need not be frivolous, unreasonable, without foundation, or in bad faith. If he simply loses, he pays. Again, check your medical staff bylaws. A lot of them have been amended and updated recently. So here's a sham peer review pearl. If the hospital administration or someone representing the hospital administration tells you that you don't need an attorney, or that you won't be allowed to have an attorney present at a peer review proceeding because it will go better for you if they keep this matter in-house, that is a sure indication that you need a knowledgeable and experienced attorney to protect your rights. So we have some free membership benefits. Just because you're an AAPS member, you have access to the AAPS Sham Peer Review Hotline, which I run on a pro bono basis to provide helpful information. And we have the AAPS Limited Legal Consultation Service run by Andy Schlafly. And these are free benefits of your AAPS membership, which you can access through the toll-free hotline to headquarters. So I would urge physicians, if you have questions, call. It's better to call early as opposed to late. And careers, for example, have been saved by simply telling the physician, look, if you resign from the hospital, they're going to report you to the data bank. So you may be looking at something that you feel you're not going to get a fair hearing anyway in the hospital, and they've convinced you that you should just resign. Don't do it. You're better off fighting, creating an independent record which can then be used in litigation later on. And so calling early is better than calling late. And I think we have time for a few questions. Thank you.
Yes, I generally like loser pay, but it should be a two-way street. Is there any move to legislation in the states to make it a two-way street, where if the hospital pays, then they pay, I'm sorry, if the hospital loses, then they pay the legal fees of the physician?
Not that I know of. Annie, any comments on that?
Can you tell us the most common reasons that hospitals try to utilize sham peer review? Why do they try to get doctors off?
Yeah, the reasons are varied. In fact, I give sort of my signature talk called The Dark Side of Peer Review. I've given that talk 41 times now, 17 different states. I have a slide, mostly to county medical societies. I have a slide that goes through the various motives, and it tends to be things like anti-competitive. Maybe it's jealousy, maybe it's professional jealousy. They're getting better results. The patients like the targeted physician better. Discrimination is a big one. The discrimination underlying sham peer reviews is becoming a more common motive. It may be someone who has personal animus against you that just wants to get you back, teach you a lesson or whatever. So there's a whole lot of improper motives. But the key thing is they're improper. They are not motives that involve the furtherance of quality health care or making patient care safer.
I remember that case with that Dr. Fitzgibbons, but I cannot remember what prompted those just extreme maneuvers to get him off the staff.
Well, if you're asking what led to it, he was criticizing this healthcare system that was about to purchase the hospital because they didn't have the best record of managing hospitals, and he was highly critical, highly outspoken about that. But the hospital went way beyond. There was some sham peer review involved. They were trying to get some quality care concerns brought against him. But they jumped right over that and went to these other things, and it was shocking testimony. I will tell you that the testimony's posted on the AAPS website. There are things even more shocking than I went through today in the testimony. If you want to read it, it's there on the AAPS website.
One thing I've noticed is that the hospitals that have actually hired companies like Greeley Consulting or Horty Springer have interestingly dropped courtesy privileges from the choices versus those that hadn't that still have courtesy privileges. Is the peer review tactics part of this? The hospital cites it was JACO, but I haven't found anything conclusive that JACO actually drove this. Do you have any further information on the tactic of taking away courtesy privileges as a choice?
No, and I'm not aware of the Joint Commission requiring anything. However, remember this, that hospitals lobby the Joint Commission to get things and regulations in place that they want. They lobby them. And then when the standards are put in place, they say, well, we don't have any choice. We have to follow them. The Joint Commission requires it. But they lobbied to get them there.
Michael Masumi from Maryland. Larry, thanks for a great talk, and also to Andy. I'd like you to expand on the issue of standard of care as it relates to the geography, meaning that there's a standard of care in any given area of medicine apply only to a state? Can you expand it to interstate? Can you go internationally? Because there's so many areas of medicine where the standard of care varies considerably. And in defending yourself or when you go in front of a board, do you have the ability to bring opposing standards of care as testimony, or are you limited by the state to only the people practicing in your own state?
Yeah, a good question. Not sure I have the answer. There is a Cardozo Law Review article entitled Blacklisted that goes over some of this and that points out that the standard of care that's used to prosecute physicians in peer review varies widely from geographic location to geographic location. And so whether or not and the review article, basically one of the conclusions is that the possibility of losing your privileges has more to do with geography than it does to actual quality of care or actual standard of care.
Larry, I have a question. Just looks like the National Practitioner Data Bank, whatever the reasons for starting has become an instrument of abuse for the hospitals. So why don't we actually fight to make sure that every charge which is run through a sham peer review does not destroy a physician's career?
In other words, get rid of the National Practitioner Data Bank.
There should be a categorization. Some of these disputes which are like he said, she said, should not lead to disqualification.
So the problem with the data bank, data bank came as part of the HCWA law, and it was actually implemented in 1989. The law was passed in 86. And the problem is under the law, the data bank has no authority to review the merits or lack thereof of the case and remove reports based on that. AAPS has gone to Congress to try and lobby for whistleblower protections. That's another improper motive. Sometimes physicians who are strong patient advocates and complain of quality care problems or patient safety problems in the hospital are retaliated against, and sham peer review is one of the main ways they retaliate. And we've gone to Congress and tried to advocate for strong whistleblower protections for physicians. That didn't go anywhere because hospitals like things the way they are. They're a wealthy and powerful lobby, and that's kind of the way that goes. But it's the data bank's part of the law, and unless we get rid of the HCWA law, which is not likely because, again, hospitals are going to fight that tooth and nail, we can't get rid of it.
Thank you so much for bringing this talk. Question I have is, in your talk, when you're talking about sham peer review, the reasons that it's brought up, you brought up a fair amount of physicians actually initiating sham peer review. And, you know, we're a very opinionated group of professionals, and it's very easy to armchair quarterback what another physician does, and I've been guilty of that too. But with the advent of more employed physicians, are you seeing more and more that the physicians are turning on each other, that we're actually at times really hurting our own profession with this sham peer review?
Yes, and usually they do it without a second thought. So the MEC is the committee in the hospital, the last stop for the peer review before it goes on to the board of directors. And because hospitals are employing more physicians, making more exclusive contracts, particularly for heads of departments, you may find that in your hospital, a majority of the MEC is financially beholden to the hospital, and they are loath to bite the hand that feeds them. So they'll go along, sure, kill off a colleague, no problem. It's not affecting us. We got a good contract with the hospital. It's totally unethical. On the other hand, in some of these places where I've given the talk, the dark side of peer review, I've had people call me afterwards and say, you know what, I sit on peer review panels and we're doing peer review differently now that we know what to look for as far as how hospitals abuse the system, the tactics that they use. So they're more vigilant. The ones who are doing the peer review and who are not biased because they're financially beholden are doing it differently because they know of the tactics. Okay, very good. Thank you.